The judgment and order in this matter is the unanimous decision of this court. Our full reasons will be part of the record. I will only read out a brief summary of our judgment and the order of this court. Chapter 3.5 of the Democratic Alliance, which I will refer in as the DA's Federal Constitution, deals with the cessation of membership. Clause 3.5.1.2 thereof provides that, and I quote, "A member ceases to be a member of the party when he or she publicly declares his or her intention to resign and or publicly declares his or her resignation from the party." We herein refer to this as the cessation clause. The DA relied on set provisions of the cessation clause for its notification on the 3rd of May 2018 to Ms. De Lille that the membership in the party has come to an end. As a result of a public declaration which she has made to one Mr. Eusebius McKaiser on a radio talk show on the 26th of April 2018. In terms of the DA's Federal Legal Commission rules, Ms. De Lille was given 24 hours to provide clear and unequivocal reasons why a membership had not ceased. Ms. De Lille responded to this demand by timelessly filing reasons in which she denied that the cessation clause was of application to the statements she had made during the interview, which she claimed pertained only to a possible expression of an intention to resign as mayor after she had cleared a name, and did not constitute the expression of an intention to resign from the party. She further stated that in the event that the party intended, nonetheless, to determine that the membership had ceased, she intended to challenge the validity of the clause on a number of grounds, including whether she had in fact expressed an unequivocal and unconditional intention to resign as a member of the party, and whether the clause violated the provisions of the Promotion of Administrative Justice Act, herein after referred to as PAJA, or was implemented in a procedurally unfair manner. On the 6th of May 2018, Mr. James Self, a senior functionary in the party, duly referred Ms. De Lille's submissions regarding the cessation of a membership to the chairperson of the Federal Legal Commission, the FLC, who in turn appointed a 3-member panel. In terms of the FLC rules, the panel was required to make a determination whether, on the papers presented to them, her membership had come to an end. On the 6th of May 2018, the panel found that this was indeed the case, and accordingly recommended that the Federal Executive, or FedEx, confirm the cessation. The FedEx confirmed the cessation and proceed to implement the consequences thereof. Mr. De Lille raised a number of review grounds. Principal amongst them was a multi-pronged constitutional challenge to the cessation clause on the basis that it allegedly violated a number of her constitutional rights. The other main alternative grounds advanced amongst others were whether the conduct of a political party when it terminates the membership of a member who is a public office bearer, such as an executive mayor, must be viewed through the prism of PAJA. And if so, whether Part C of the FLC rules were inconsistent with PAJA, and whether the DA indeed complied with the procedures laid down in its own constitution when invoking the cessation clause. The DA defended its decision to terminate Mr. De Lille's membership. According to the DA, Mr. De Lille's position as a councillor and as executive mayor was dependent upon her membership of the party, which he voluntarily accepted would be regulated by the terms of its constitution and its rules, and her membership was dependent upon her continued compliance therewith. According to the DA, the purpose of the cessation clause was to ensure that its members remained loyal to the party and committed to its values. It held the firm view that on an objective assessment of the statements Mr. Lille made during the radio interview, a reasonable listener would have understood that these amounted to a public declaration of an intention to resign from the party and not an intention to resign from the mayoralty. The DA contended that the loss of membership occurred ipso facto by operation of the cessation clause, and the role of the FLC and FedEx was simply to determine whether or not the relevant act or acts had been committed in breach of the said clause, and neither FedEx or the FLC had any true discretionary powers in this regard. As a result of the approach we adopted, it was decided that this matter was capable of being decided without the need to determine the constitutional issues that were raised. Similarly, it was unnecessary to widen the scope of the review by reference to Badger for the reasons set out in our judgment. In our view, the real crisp issue for determination was whether the DA complied with its federal constitution and its rules when it decided to invoke the cessation clause. Much debate centered around the interview Mr. Lille had with Mr. McKaiser and whether the statements he made during the course thereof fell within the ambit of the cessation clause, in that they constituted a public declaration of an intention to resign from the party, as opposed to an intention to resign from the mayoralty. It was common cause that it is only if such declarations amounted to the former that the further question of whether or not there was proper compliance with the prescribed processes that were to be followed in consequences thereof arose. And it's only in such circumstances that the further alternative grounds of challenge could be considered. In commenting in their judgment on their understanding of what Mr. Lille said during the interview, our learned brothers Gamble and Samela J clearly also understood her declarations to amount to the expression of an intention to resign from the party and not from the mayoralty. Counsel for Mr. Lille contended that even if we were minded to agree with Gamble and Samela J, and were also of the view that what she expressed during the interview amounted to an intention to resign from the party, it did not necessarily follow that the provisions of the cessation clause were applicable. In this regard, it was submitted that her declaration was not unequivocal, as it was conditional upon her clearing her name at some indeterminate date in the future, and it was submitted that on a purposive interpretation, it could never have been intended that the clause would apply in such circumstances. In response, counsel for the DA submitted that although her expressed intention was contingent upon a future event, it nonetheless was clear that it amounted to an unequivocal intention to resign. Put simply, it was only a question of when she would resign and not if, and there was therefore no good reason why the clause should not find application. In our view, it is not necessary for the purpose of this judgment to attempt to resolve which interpretation is the correct one for the reasons articulated in our judgment. The fact that the statements which were uttered by Mr. Lille may have amounted to the expression of an intention to resign within the meaning of clause 3.5.1.2, in our view, does not necessarily lead to the conclusion that the membership ceased, as was submitted by the DA, either automatically or otherwise. Having considered the argument advanced by the respective counsel and the case law referred to, our finding is that in terms of the DA's federal constitution and its rules, membership does not cease automatically by operation of law. It is, in fact, dependent upon a determination which has to be made to that effect by the FLC, which must in turn be confirmed by the FedEx in order to become operative. That has two further important consequences. Firstly, it must follow that where there is a material defect in relation to the process, i.e. where a FLC panel was not properly constituted in terms of the party's constitutional rules, then there cannot be a valid determination made that membership has ceased. And secondly, there can be no valid and effective confirmation of such a determination by the FedEx. The composition of the FLC and whether it was properly appointed and constituted in terms of Clause 11.1.1 is therefore vital. The DA submitted that at the time Clause 11.1.1 was inelegantly worded and open for more than one interpretation. According to the minutes of the meeting, which was held on the 5th of June 2015, following upon the party's Federal Congress, FedEx duly appointed the chair and deputy chair of the FLC. The party's federal leader then expressed a desire to serve on the selection panel, which was to make recommendations to the FLC for the appointment of the other panel members, and this request was accepted by FedEx. Technically speaking, this would mean that the selection panel was improperly constituted, as it would be comprised of an additional member, i.e. the party's leader, who was not authorized to be on the panel. But according to the papers filed of record, when the selection panel met thereafter, the leader was not present, and the FedEx chair and the 9 provincial leaders assumed the role of recommending all of the 20 principal and 10 alternate FLC members for appointment by the Federal Council, which in terms of their constitution is a different body, approval for which seemingly granted by the Council on 25th to 26th July 2015. It appears that the chairperson of the FLC and the 9 provincial leaders were not included as members of the FLC in this process of nomination and appointment. According to the DA, the first way to read the said clause was that the selection panel as a whole was to recommend all 20 principal members and 10 alternates of the FLC, and as their function was therefore complete, they did not form part of the FLC. On the other hand, it could be read that the selection panel constituted the first 10 members of the FLC, and its task was to recommend an additional group of up to 20 principal members and alternates, of which it would be form part. The DA said that it understood the clause to be read in the first way, and it appointed members of the FLC panels in 2011 and 2015 in that manner. However, as we have attempted to explain, contrary to this, it was also submitted by the party that once the initial 10 members had been appointed, the selection panel was complete, and the reference in clause 11.1.1 to the additional members was to be understood as constituting a reference to a different additional panel. In the circumstances, so it was contended, the initial selection panel was never intended to be part of the FLC, and Ms. De Lille was mistaken in regard to her understanding and interpretation of the said clause. Put simply, it was contended by the DA that the clause referred to 2 different bodies, i.e., an initial group of 11 members would constitute a selection panel, the first 10 referred to in the clause together with the chairperson of the FLC, and another group of up to 20 members plus alternates would constitute the FLC. According to Mr. Self, the original 11 members of the selection panel were considered to serve only to identify the members of the FLC, but did not themselves ever serve as members of the FLC. We found the differing interpretations which were put forward by the DA in regard to the proper meaning to be afforded to the clause to be strained and confusing. In our view, on a proper reading of the clause and the Constitution as a whole, there can be no uncertainty or vagueness as to how the FLC should have been constituted. Firstly, at its first ordinary meeting after its Federal Congress, FedEx was required to elect the chairperson and deputy chairperson of the FLC. Thereafter, FedEx was required to appoint a group of 10 further additional persons who were to be as objective as possible, preferably one from each province, who would form a selection panel, together with the FLC chairperson, and not the chairperson of FedEx, as seems to have been the case. This panel was required to make recommendations to the Federal Council for the appointment of the other members of the FLC, comprising up to additional 20 members, of whom at least 15 of the principal and 6 of the alternates were to be legally qualified persons. According to the DA's constitution, the FLC is an important structure within the party. It is a body from which members are drawn to serve on disciplinary panels, and panels which must make determination as to the cessation of persons' membership. To this end, it is understandable why the drafters of the Constitution would insist that at least 15 of the principal and 6 of the alternate members were to be legally qualified persons. The intention was clearly to create an FLC that would be comprised of mostly legally trained and skilled people, and that all the members would be able to bring about an objective and impartial mind to bear on the issues they were to decide upon. It is abundantly clear that on the DA's own version, clause 11.1.1 was not complied with, and such non-compliance was material and not trivial, as the party tried to suggest. Not only was the initial FLC selection panel not properly constituted, but the entire FLC itself appears also not to have been properly constituted, in that the 11 members of the selection panel were not considered to be part of it and never served on it. In our view, this must mean that the FLC panel, which was appointed to make a determination in respect of the alleged cessation of Mr. Lille's membership, was also improperly constituted, and this must too was in effect conceded by the DA's counsel when pressed upon the point. The FLC, within the context of the DA's constitution and body politic, is an important structure and has wide powers. The composition of the FLC must accordingly be within the four corners of the federal constitution. This is in line with the principle of legality. A failure to do so certainly falls outside the boundaries of the federal constitution. The non-compliance of the said clause, having regard to the purpose of it, was material and properly evaluated brings about an irregularity that justifies a ground for review. In our view, the fact that Mr. Lille may have somehow participated in some of the processes cannot render an otherwise improperly constituted FLC to be lawful. It follows that on this ground alone, the cessation of Mr. Lille's membership cannot stand. But there is, in our view, a further material reason why the decisions in question are reviewable. As we have previously pointed out, the DA's constitution further provides that in the event of a case of cessation, and assuming Mr. Lille did publicly declare that he intended to resign from the party, then the process or processes to be followed were to be further regulated by the rules of the FLC. Chapter 10 of the DA's constitution in turn provides that the FLC must determine the rules of procedure which may be applicable to it, which may not be in conflict with the federal constitution. The procedures that are applicable to the proceedings of a panel are dealt with in clause 10.5 of the federal constitution. Clause 10.5.1 provides as follows, and I quote, "The rules of procedure prescribed by the Federal Legal Commission must apply to all proceedings of a panel, provided that the rules of natural justice must at all times be adhered to. In particular, a panel must not make any adverse finding against any person unless 10.5.1.1 the person has been sufficiently informed of every allegation against him or her and has been given the opportunity to rebut the allegations, and 10.5.1.2 he or she has been given the opportunity to submit evidence of mitigating factors," unquote. It is apparent from these peremptory provisions that before making an adverse finding against Mr. Lille, the party was required to give her an opportunity to submit evidence in mitigation, which it is common cause it did not do. In our view, and as further elaborated in our judgment, the party's failure to comply with the provisions of clause 10.5.1.2 of its own constitution amounted to a further material irregularity which vitiates the decision that was arrived at, namely that Mr. Lille's membership had ceased to exist. For these reasons, it follows that the relief sought in paragraph 3.1 of the amended notice of motion part B must succeed with costs, including the costs that stood over in relation to the application for interim relief in Part A. In the result, the following orders made. The determination by the first respondent that the applicant has ceased to be a member of the DA in terms of Clause 3.5.1.2 of its federal constitution is declared to be unlawful and invalid and is reviewed and set aside with costs. Such costs shall include the cost pertaining to the application for the interim relief in terms of Part A and the costs of the employment of two counsel.
I agree.
It's so ordered. Court will adjourn.
Sorry. Can I go? Sorry.
Morgen is het goed. Ja, 6 maanden van morgen.
Thank you.